All rise. The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. Is now in session. Thus said the state and its honorable court.
Thank you, Mr. Soar. Good morning. I'm Judge Hunter Murphy. I want to welcome you to the North Carolina Court of Appeals. Joining me on the panel today, to my right is Judge Jeffrey Carpenter, and to my left, Judge Fred Gore. We are here this morning with one case, which is RCOA number 20-660, State of North Carolina versus Brichikov. I noticed that everyone is in compliance with our COVID guidelines, and just remind you that except for when you're arguing, please keep your mask covering your mouth and your nose. And that goes for everyone in the courtroom. So thank you very much. And we'll be with the appellant.
May it please the court. I'm Gordon Widenhouse. I represent Mark Brichikov in his appeal from a conviction for second-degree murder and the imposition of a sentence of 338 to 414 months in the Superior Court for Wake County. I'd like to try and reserve 5 minutes for rebuttal.
Thank you, sir.
A criminal defendant is fundamentally entitled to have the jury instructed on any lesser-included offense that is supported by the evidence. Of course, the jury can only consider a lesser-included offense if the trial court submits it and instructs on it to the jury. In this case, the trial court denied Mr. Brichikov this right when it refused his request to instruct on the lesser-included offense of involuntary manslaughter. When the evidence in this case is taken in the light most favorable to Mr. Brichikov, as it must be, it is clear that the trial court erred. This error cannot be deemed harmless beyond a reasonable doubt because it is impossible to know what the jury might have done if it had been given the option of something between second-degree murder and not guilty. Thus, this court must reverse the conviction and award Mr. Brichikov a new trial. In this case, the facts are relatively straightforward. Mr. Brichikov and his wife, the deceased Nadia Brichikov, had what I think can only be described as an unusual and somewhat volatile relationship. They were both drug addicts. Mr. Brichikov, right before this incident, had spent about a month in a rehabilitation facility in this area. His wife was in jail on a drug charge, had been in jail on a drug charge. She had agreed to cooperate with local authorities and was released from jail and was staying with another man, Clay Trott, whom she had been involved with for 5 years, living with him, sexually involved, even though he acknowledged he knew that she was married to Mr. Brichikov at the time. She went to stay with Mr. Trott and apparently overdosed on fentanyl, fell, cut her head, gashed her head, was taken to the hospital. They used Narcan to revive her, and she then went back to the place where she was staying with Mr. Trott, but got him to take her to the Knights Inn in Raleigh. During that time, she was texting Mr. Brichikov and communicating with him and encouraging him to come and stay with her. She told him she had been in the hospital and had overdosed. In these text exchanges, he asked if they Narcaned her. She said that they had, which indicated he understood the nature of her addiction, the nature of the kinds of narcotics she was using, and what would happen if you overdosed on fentanyl, and what could be done to revive the person. during that particular day, and Mr. Brichikov at the time had just left the rehab facility and had gone back to work with a guy who sets up, in Raleigh, who sets up events, I guess, sets up tents and things like that for local events, and had worked with him that day, and again during the day is texting back and forth with Nadia. He encourages her. She said she's going to go to the Knight's Inn. He obviously knows where the Knight's Inn is and the kind of place it is, and he asks her not to go there. He tells her it's not a safe place, that there are a lot of narcotics available there, but she chooses to go to the Knight's Inn anyway, and Mr. Trott takes her there early in the morning that this incident occurs, late that evening and early in the early morning hours of the next day. And she gets dropped off at the Knight's Inn 9, 10 o'clock in the morning, and she doesn't check into a room until the middle of the afternoon, suggestion or indication being that she had to raise the money to do that, and the way she apparently made her money, according to the record, was some shoplifting and prostitution, another activity that happens apparently at the Night Inn. Again, all during the day, having communications with Mr. Brichikov and encouraging him to come and spend some time with her. So Mr. Brichikov works that day and then gets taken to the Knight's Inn that evening. And we know from text messages back and forth some of what was going on, but we know from video surveillance a lot of what happens at the Knight's Inn. We know roughly the time that Mr. Brichikov gets there. We know the time that he goes to room 241, which was the room that Nadia had rented and where she was staying. And they're there in that room for a couple hours. And then we know from video surveillance he leaves for a while. He goes to a convenience store. He stops at a red car that a detective suspected was where he could get narcotics.
Mr. Whitehouse, let me ask you a question about that. If we were looking at this from the state presenting enough evidence to get past a motion to dismiss, on getting the drugs and the alcohol, why isn't that just mere speculation at this point?
Well,
Even though you have this officer saying, yes, looks like a drug transaction, how do we have anything beyond mere speculation that, one, he got these alcohol and got drugs, or two, that's what she ended up taking? I think that's kind of part of your argument, at least as it comes to a duty to act.
Well, I mean, to some extent it's speculation, but it was the opinion of the officer who watched the surveillance video and testified without objection that he surmised, speculated, opined, thought that he might have been buying drugs at the car. I mean, again, we would assume that the officer was allowed to testify based on his training and experience, and his training and experience and knowing the nature of the Knight's Inn, believed that he might have been getting drugs at the car. I believe there was enough of the surveillance video that they saw him purchase alcohol at the convenience store, although I may be wrong about that. But at any rate, whether it was speculative or opinion, we take that evidence in the light most favorable to Mr. Brichikov when it comes down to whether the evidence supports an instruction on involuntary manslaughter.
Well, let me ask you that about light most favorable a little bit. If it's mere speculation, do we consider that speculation alone to be enough evidence to be entitled to an instruction? Or does it have to raise to the level of being sufficient or substantial?
Well, I think the answer is you have to take all the evidence. All the evidence in this case is not speculation. We know that these two people interacted from 10:30, 11 o'clock the night before Nadia dies until 3:45 a.m., and we know that Mr. Brichikov comes and goes from the motel room, and Nadia is waiting for him half the time, in several indications, standing outside the room, smoking a cigarette on her cell phone, and then lets him back in. And they go back in together. I mean, I think it's important that there's no indication from these surveillance videos that he forced his way back into room 241, or that she forced him to leave. It looked like, I'm going to say normal coming and going, but there's nothing normal about what was going on in this case, at least not in terms of my experiences. But it didn't look like anybody was saying, get out of the room and don't come back, or, let me back in the room, whether you want to or not. I mean, he wasn't beating on the doors, he wasn't pushing the door, forcing his way in. And she seemed to be doing all right, standing outside the motel room when he would leave, again, on her cell phone, smoking a cigarette, and then they go back in together when he comes back.
All right, Mr. White, let me ask, just because we're getting kind of far into your argument, I want to give you an opportunity to be heard on some of these other issues or concerns that I have. Is your contention that if the trial court had given the full pattern jury instruction on second-degree murder, 206.30A, which includes the lesser included involuntary manslaughter, that instruction itself would have been enough to cover what I call your assault-based argument and your omission-based argument? Do you think that instruction would have been enough to cover both of those portions?
Yes, I think it would have been, absent some additional request by defense counsel. I mean, if all you request is an instruction on involuntary manslaughter, even if you have two theories, which I call, culpable negligence in terms of an act and culpable negligence by omission, if you want further explanation of that, the burden, beyond the pattern jury instructions, the burden's on defense counsel to ask for that.
And there was no written request at any point for additional instruction, additional language to an involuntary manslaughter?
No, and my argument is not that there needed to be something beyond the pattern instruction on involuntary manslaughter, because that's what was requested, and that's what I believe is supported by the evidence in this case on either of those theories, that it is, it's an intentional act that is too dangerous to human life, that it's culpably negligent to do it. And then, again, that's why it's important that he ask Nadia, did they narcon you after you overdosed? Because that gives some indication that he's aware of the danger of using fentanyl and what happens when you overdose with fentanyl and what can be done to remedy that overdose. Apparently, this narcon it's almost like a miracle. You just regain consciousness and are past the overdose. And so I guess it's like smelling salts when somebody passes out. Sometimes it's smelling salts and people just are revived. So he knew and understood the danger of fentanyl and that she tended to use that drug. So he understood that and would have known if she was using narcotics that night, what would have needed to be done to get her some medical assistance. So it's both, plus, if things get out of hand and there's a fight, and during the fight, I've hurt the person that I have been fighting with, and I see that they're on the ground, that they're bleeding from the head, and their bridge has been knocked out of their mouth, I know that person needs medical help. And so in addition to me being culpably negligent for engaging in an intentional act that's dangerous to human life, when I do that and then don't take some action to get medical assistance for the person that I've assaulted, then there's an omission on my part for failing to get that kind of help.
Well, let me ask just a little bit more about that, because at trial, it seemed like the trial attorney was arguing more that there was a duty between them for him to have acted based on them being husband and wife and having a special bond. And you kind of get around to that a little bit where you bring up the Mason case, but is your argument the same, that it's about this special bond they had and he had a duty to act whether he caused anything, brought the drugs, or not?
No, he has the duty to act, I think, based on the being a human being and understanding that we have a duty to our fellow human beings when something has happened and we should try and get medical assistance. I think.
But we don't have any cases in this state that hold that concept. If I walk in on somebody having a heart attack in the middle of the floor and I turn around and walk the other way, I might be going to hell, but I'm not going to be criminally liable for that.
Well, that's true, but again, it's a situation where you're not going to be charged with murder. And what happens when you're charged with murder is there's got to be some culpable act on your part in order for the murder prosecution to proceed. So if I walk in on somebody and see them in medical distress, I don't have an obligation to do anything, and I can't be charged with homicide, I don't think, if I don't do anything. So it's when I'm somehow involved in the incident, and then I don't do anything to try and take care of it. I think that's essentially what this court was saying in what I call the Zach case, in Re ZAK, is, when you're participating in narcotics activity, using narcotics with other people, and you see that one of them is having a bad reaction, there's some duty on your part. Again, at least if you're charged with homicide in that situation, then, you can have an entitlement to an instruction on involuntary manslaughter based on a culpable omission. So just so I can make sure I'm clear on your, because it seems like in the brief it's coming across that these are two different options. But is it your position that he's entitled to the involuntary manslaughter instruction based on the culpable negligence of the assault, and then also on the omission, but for the omission you also have to have the assault element to be entitled to it in the omission? Correct. I think there are two bases for his request for involuntary manslaughter, either one of which is sufficient, and neither one of which is independently necessary. I mean, you don't have to have the basis for the omission in order to be entitled to involuntary manslaughter for the culpably negligent act. And as to that theory, and this is what I'm trying to parse out, and I'm not trying to put you on the spot, but can you point me in the transcript, looks like starts around 867 is the charge conference, where this theory of assault plus omission is argued to the trial court judge for the entitlement to the instruction. To me, it seems as though the trial attorney was focusing on the omission. The trial court judge on the next day comes back and does talk a little bit about Zach and how they kind of come together. It still doesn't rise. But it seems to me the trial court judge's, or the trial court attorney's argument in theory was based on the omission prong and not the assault plus omission. So if you have something you can point me to, I'd ask you to guide me there if you can in the charge conference. I think the trial attorneys asked for involuntary manslaughter based on the evidence in the case. Now, granted, they made more of an argument about the omission and the Zach case, but I don't think the law in North Carolina is I have to give any basis for my requested instruction other than it's supported by the evidence. And that's the purpose of the charge conference, is to alert the judge, these are the things we think you're supposed to instruct on. And if I say, I want you to instruct on involuntary manslaughter, if the judge doesn't ask me any questions in particular, I don't have to make much of an argument other than it's supported by the evidence. And
So would it be your position that I believe it's Golder from our Supreme Court in the last couple of years, when it came to motions to dismiss, that whatever theory is argued, if you make the motion to dismiss, that's enough to preserve any theory?
I believe that.
Do you think that we're in the same situation here with the jury request?
I believe that principle has been, if not eradicated, certainly reduced substantially by the recent, I think it's Gonder case from the state Supreme Court, where they say, if you move to dismiss, that preserves any basis for the motion to dismiss. I think the same thing would be true for a jury instruction. Now, I can't stand up at the close of the evidence or at the charge conference and say, Your Honor, I want you to instruct on everything that's appropriate. That's not sufficient. But if I tell the judge I want the pattern instruction on involuntary manslaughter, I don't think I have to give any other reason unless the judge asks for it. And if I give one reason and there's another reason that supports it, as long as it's supported by the evidence, that's enough to preserve the issue for this court to review. I mean, part of the obligation...
Counsel, on that point, I'm sorry to interrupt you, but on that point, is it at that point, after you've requested the manslaughter instruction, that it then comes back in the onus on counsel to request a specific instruction?
Okay. And if I understand the question, I think the onus is on counsel to ask for the specific instruction. I want the pattern instruction on involuntary manslaughter.
And it's preserved once you've asked it, but the onus of what specific instruction with some detail comes back once it's been preserved.
Correct, because I think what we're talking about is what's the basis for my request as opposed to what my request is. My request is I want you to instruct, well, he doesn't want to instruct on first degree, but if you're going to instruct on first degree, I want you to instruct on second, and I want you to instruct on involuntary manslaughter. And I think the trial lawyers, the defense lawyers, were very focused, and appropriately so in this case. They didn't ask for an instruction on voluntary manslaughter. They didn't think there was apparently any basis for that instruction, that lesser included offense, and I don't think there was a basis for instruction on voluntary manslaughter. But there was for involuntary, and I think they went beyond the mere request. They went beyond saying the evidence supports this. They went beyond talking about the nature of the assault and putting on evidence about what was the actual cause of death. I mean, they had 3 pathologists eventually testify in this case. And so I believe the defense lawyers did more than what, at least in my experience of been doing appeals for longer than I care to admit, but it's running up on 40 years, a really excellent job at the charge conference of specifically requesting what they wanted and telling the court why. And that's all we require to preserve the issue of what's a valid jury instruction and what then becomes the obligation of the trial court to instruct on the lesser included offenses that are supported by the evidence. I really think the case that is so important in this case, I call it the Debase Case. I'm not exactly sure how to pronounce it, but it's cited in our brief and also in our reply brief. And that's a situation where 2 people got in a fight and the defendant was using a bottle, and during the fight the bottle breaks and the deceased is cut with the broken bottle, and then the defendant pushes him into a fire, and they don't even know each other. The thing that apparently precipitated the incident in that case was the defendant asked the deceased girlfriend if she wanted to do narcotics with him. They were at a bonfire, some sort of, I guess, a party where everybody's gathered around this fire, and apparently the deceased didn't take kindly to the defendant asking the deceased girlfriend if she wanted to use drugs with him. And there was stabbing in that case, there was a beating in that case, and then the defendant ran from the scene and tried to get a motel room to evade the cops and the police. And this court said that's sufficient evidence of involuntary manslaughter. And the court was clear, saying that it was an intentional act where he struck the deceased with the bottle, but the evidence is susceptible to the interpretation that at the time he did that, he didn't know or had no reason to believe that the bottle would break or did break. and the full nature of the damage that was done and the death resulting from this series of events would, under the decisions of this court and the court across the street, would support an instruction on involuntary manslaughter. And that case, it seems to me, is about as close to being a case on all fours, so to speak, using language that probably is outdated, but we used it when I was in law school a long time ago. But it's very close to being, on all fours with this case. And so it really seems to me that following Debase, that the trial court erred here in not giving a requested instruction on involuntary manslaughter. Again, constitutional entitlement to an instruction on lesser included offense. Evidence taken in the light most favorable to the defendant, the requester of the lesser included offense. In this case, taking the evidence in a light most favorable to Mr. Brichikov would have supported an instruction on involuntary manslaughter. And merely because the evidence might be sufficient to support a conviction for second-degree murder doesn't make the error harmless beyond a reasonable doubt. Again, because unlike if the jury had convicted of first-degree murder and thereby rejected second, perhaps at that point, failing to give involuntary is harmless. But the jury rejects first-degree murder in this case, which means they rejected specific intent to kill and premeditation and deliberation, and they find second-degree murder without an option to give the lesser included offense in a situation where Mr. Brichikov, through counsel, admitted the assault in closing argument. So in this situation, the trial court erred, and this court should award Mr. Brichikov a new trial.
Mr. Whitehouse, I want to give you a question to think about while you're waiting for rebuttal. In State v. Mason, which you rely on in part, we do rely there on a statutory obligation between a parent and a child arising to involuntary manslaughter. So I'd like to know if there's any statutes or common law principles that you would ask us to apply regarding the duty between the husband and a wife to kind of to see if this is closer to Mason than I'm seeing it being right now.
I don't have a statute to offer to the court, and I'm not sure what the common law obligation of a spouse is when the other spouse has been injured. But again, under the Zach case, knowing that the damage has been done by something in which the defendant was participating, that creates the obligation in this case.
Thank you, sir. We'll hear from the state.
Good morning, Your Honors. May it please the court. My name is Mark Sneed. I'm with the North Carolina Department of Justice, and I'm here this morning on behalf of the state of North Carolina. In this case, Your Honor, the state contends that the record evidence reflects that all the elements of second-degree murder have been satisfied. Second-degree murder, as you know, is the unlawful killing of a human being with malice but without premeditation or deliberation. We have 3 medical experts who have opined that defendant's violent assault on Nadia contributed to her death. The assault resulted in a broken nose, broken cheekbones, and a broken jaw. All 3 labeled Nadia's death a homicide. There were also comorbidities of her...
I just want to be clear, because I think it came up in the reply brief, but a homicide includes involuntary manslaughter, does it?
Yes, sir, that's correct. Right. But I'm just going to the elements of second-degree murder, that we have a homicide here. All 3 of these labeled Nadia's death a homicide. Although we have comorbidities of the opioids being in her system, as well as a very serious heart condition, which probably caused her heart to stop, nevertheless, all 3 medical experts determined that Nadia's death was a homicide, and this assault contributed to her death.
Counsel, on that point, I know you're getting started. Is it not true that there was some testimony that, at least from one of the experts, since you're on the record right now arguing that all three declared a homicide. So isn't it true also that at least one of the experts testified that the injuries by themselves that were at the result of the defendant would not have resulted in death?
Are you referring to the facial injuries?
Yes.
I believe that's correct, Your Honor. There is in fact testimony that says exactly what you've said. However, they all said that all three comorbidities combined contributed to the death of Nadia. And so sitting alone or standing alone, the assault may or may not have killed Nadia. However, when you combine the assault as well as the opioids in her system and the heart condition that she had, they all contributed to her death. So I don't think that there's any testimony that says any of those conditions standing alone would have killed her. However, this assault was approximate cause of the death of Nadia in the minds of all three. All three of them labeled this a homicide. And so when we're looking at the elements of second-degree murder, the element that really differentiates second-degree murder from involuntary manslaughter is malice. When we look at malice, we have three theories as to how the state can establish malice. First, express hatred or ill will or spite. Second, we have the commission of an inherently dangerous acts in such a reckless and wanton manner as to manifest a mind utterly without regard to human life and social duty and deliberately bent on mischief. And that's where I think we are here, Your Honor. And third, we have a condition of mind which prompts a person to take the life of another intentionally without just cause, excuse, or justification. Our North Carolina Supreme Court in State v. Bush has previously stated that the intentional use of a deadly weapon approximately causing death rises to a presumption that 1, the killing was unlawful, and 2, the killing was done with malice. If we look at this particular case, we have the defendant who's using his fist to violently assault Nadia in a manner that results in broken cheekbones, a broken jaw, and a broken nose. I don't think that we can doubt that there is intent there. He beat her to the point where if you held her head down, you could still move her face without moving her head. So her face was shifting as a result of this violent assault. And the presumption arises that there is malice. However, the presumption is rebuttable. The only way to rebut this presumption if the defendant is able to produce evidence that shows that any element can be challenged, or he can challenge the element of malice. We don't have that in this case, Your Honor. In this case, we've just got an assault, which I've just described to you, which was extremely violent, and it was done with his hands. Under State v. Bush, we have the malice, we have the intentional assault, and we have the death, as was opined by all three medical examiners here in this case.
Let me ask you real quick, because I think it's the elephant, at least in my head, is in the brief, I don't see you distinguish State versus Debase. How would you distinguish State versus Debase and its situation here?
Certainly, Your Honor. Counsel says this is on all fours. I know you'll be shocked to believe that I don't believe that this is on all fours. I think that this case is very easily distinguishable. If you look at the definition of manslaughter, the definition of involuntary manslaughter is the unlawful killing of another human being without malice, without premeditation and deliberation, without intention to kill or inflict serious bodily injury. The last part is the key here. Intention to kill or inflict serious bodily injury. In the Debase case, what we have, and I will say that the court correctly decided the Debase case, but as my colleague here said, or my adversary here said, this case is not on all fours. The facts of those cases are completely different. Yes, we had two people who got into a fight. The defendant hit the victim over the head with a bottle of some sort. There was never any intention for the bottle to break, and there was no intention for him to inflict serious bodily injury or even death. And that's where I think we have a major difference between the instant case and the Debase case. That's why I don't believe that those two cases are on all fours. So you have intent here. There's absolutely no question that the defendant in this case intended to assault Nadia, and he did it violently. As a matter of fact, the jury actually found beyond a reasonable doubt beyond a reasonable doubt, that this was a particularly heinous and violent act, and that was an aggravating factor.
Do you have
So
any case law that would suggest we consider that later finding of an aggravating factor in considering the base case?
I do not, Your Honor. I
Okay.
do not. But I just wanted to point that out. The jury found this to be a heinous kind of a crime. We see the violent nature of the crime with her face, is braces shattered, and it kind of moved on its own.
Counsel, on that point, would it not be possible for the jury to have evaluated involuntary manslaughter and still use the conduct of the defendant to be an aggravator in sentencing for manslaughter as well?
I understand.
Because your argument goes beyond kind of judgment. So you're saying, hey, after judgment, they use this as an aggravator. So I'm kind of consistent with your argument
Yes, sir.
to say, could they not have done the same thing with manslaughter?
You're asking, could they evaluate him for manslaughter?
Use the conduct as an aggravating factor in sentencing for manslaughter, because your argument was post-judgment.
I do.
So I'm staying consistent with your argument, but raising the question, you're using the heinousness of it, but the heinousness of it after judgment. So I'm asking and posing the question, could they have not done the same thing with the judgment being involuntary manslaughter?
I don't believe so, Your Honor. The reason why I say that is because when you're looking at involuntary manslaughter, you're looking at intent. So in order to get to a jury charge for involuntary manslaughter, there has to be no intent to inflict serious bodily injury or death. In this case, the intent was there. So I don't think that you can kind of conflate the heinousness with the intent, because if it was heinous, then you're looking at, it was most likely an intentional act. With involuntary manslaughter, it's not an intentional act because that's not one of the elements of the charge.
Okay.
And so,
Before we move on real quick, while we're talking about the aggravating factors, we also have aggravating factor on record page 41, I believe it is. 41, number 15, the defendant took advantage of a position of trust or confidence, including a domestic relationship, to commit the offense. If we're relying on these later findings, would that statutory aggravating factor be similar to the statutory obligations in Mason to create enough of a bond?
in which case, Your Honor?
In State versus Mason, with the child, that an omission itself, given this position of trust or confidence, why would that not be enough of a bond to be similar to what we have in Mason?
I think it's different, Your Honor. I think you touched on this in your question to fellow counsel. You have a statute there where you show a parent and child, where basically you've got a child who's completely dependent on the parents for their care. Here you've got a husband-wife, and I haven't heard that there is any sort of statute that's on point that kind of talks about a special relationship between a husband and wife that would kind of give rise to an extra duty, so to speak. So I don't believe that you can use that aggravating factor here in regard to what you just spoke of.
Thank you, sir.
Thank you, Your Honor. And like I said, I think I was talking about malice. The presumption is only rebutted if the defendant is able to produce evidence that adds to any doubts or questions the element of malice here. Here we don't have that. And also, I think I just spoke to State versus Smith, but we don't even get to the issue of involuntary manslaughter if the trial court finds that that the record evidence shows that each element of second-degree murder has been met. As outlined above, I believe that they have met that burden of meeting the elements of second-degree murder.
Can you point me in the transcript where the trial court makes that conclusion, that all the elements have been met? 'Cause the way I read it is just that you're not entitled to this based on an omission. When I look at what the trial court's reasoning and ruling were, did the trial court ever make any ruling
He did
that
not.
the state had shown this?
He did not, Your Honor, not that I'm aware of, but I'm just going through the evidence and trying to walk you through it. So, And we talked about how the Debase case is different on this case. And I want to speak to defendant's argument about the omission. And so if we look at the Zach case, which defendant has cited, again, I don't believe that this case is on all fours. In the Zach case, what we have is the defendant handed ecstasy over to one of his friends, I believe. The defendant also saw that his friend was in need of medical help. But I don't believe that this case stands for an omission giving rise to a duty to aid. So if there were many kind of affirmative actions or missteps that this particular defendant took, first of all, when his stepfather came down to the basement to check on the kids, and the defendant was aware that his friend was in need of help, he lied to his father and said, basically, this kid is fine, just go ahead. At another point, the defendant actually got on the phone with a 911 operator. He's got friends in the background who are shouting, tell the truth, tell the truth, tell her what's happening. The defendant basically lied to the 911 operator and said, look, the person is fine, we don't need any kind of help. Later, he ended up going to a neighbor's house because he didn't want any sort of police trouble, so to speak, to come to him. So he basically took the person who was in need and distress to a neighbor's house, further delaying any sort of medical treatment that this victim could have gotten. And eventually the neighbor called the paramedics. Paramedics got this victim to the hospital, but at that time it was too late. And if you look at the case specifically says, at the very least, defendant's affirmative conduct precluded any other rescuer from rendering aid. At worst, it actively caused her death. So again, I don't believe that the Zach case is, in fact, on all fours.
How do you get over the portion of the Zach case, which is citing to Little versus Omega meets one, where we say risk creation behavior thus triggers duty where the risk is both unreasonable and foreseeable. The orbit of danger is disclosed to the eye of reasonable vigilance. Is the orbit of the duty. A duty arises based on evidence showing that a defendant should have recognized that a victim or anyone similarly situated might be injured by their conduct. And this is before we transition into a discussion of the acts that he did to keep her from getting help. We clearly, in my opinion, recognize a duty here at 897. So what in that language is not recognizing the same duty that exists in tort exists here for involuntary manslaughter?
So in this case, what I would argue, Your Honor, is we're basically we've got two separate theories, two separate actions here in the instant case. We've got the assault, and then we're talking about the omission. So I would say that this case is different from the Zach case in that I don't believe that you can separate the two behaviors. You have one basic transaction of facts. You have an assault, and then you have the defendant leaving. And so I would respond to your question, Your Honor, by saying that, as I outlined before, we've got second-degree murder that the evidence comports with second-degree murder. I don't believe that evidence that we previously talked about, that I've previously outlined, just disappears once he leaves to flee the scene of the crime. So I would also say that if you're looking at malice in terms of the omission, the malice is still there. It's still present. You still have an intentional act of him leaving. You see that if you read the transcript, she's very close to her death at the end of his pummeling of her. So he leaves. And so I think that you could say the malice continues by his actually leaving. So I don't believe that any sort of duty to act arises for him just at any point in time. He's already committed the crime, and this is part of the same transaction. So I don't believe that there is any sort of duty to rescue. I think you look at the facts in total. I don't think that you separate the two. You have the assault, you have his leaving. I think that that's one set of facts. You can't separate one from the other. And so from there, I would say that the malice continues, and therefore a conviction for second-degree murder was warranted. and I still believe, Your Honor, and under the facts of this case, that the elements of second-degree murder have been satisfied.
Since the jury did go to second degree and declined first degree, and there are facts that are arguable, how does the state get around the fact that there are arguable facts that the jury could have considered that the judge should have allowed the jury to evaluate manslaughter? How do you get around and that was the argument of counsel. If we were at a verdict of first degree, very hard for them to make this argument.
Right.
So using the jury's decision and arguable facts, as the law requires, in light most favorable to the defendant, how does the state get around the fact that that was possible for the jury to evaluate those facts?
So, Your Honor, I'd go back to State v. Smith. I would go back to State v. Smith in that the North Carolina Supreme Court has basically said if the evidence comports with second-degree murder, then the defendant is not entitled to a jury instruction for the lesser-included charge. As I outlined before, the state met its burden of satisfying the elements. That's just my arguing facts to you. Judge Murphy, there's no finding of fact or anything like that in there. I'm just arguing facts to you. But based on the facts that we have on the record, the state satisfies the elements. The trial court is well aware of what the evidence is, and because those elements were satisfied, then the defendant is not entitled to a jury instruction for a lesser-included offense. And, Your Honor, I think I've gone through everything that I need to go through today, but I'm happy to answer any other questions that you may have.
Mr. Carpenter, do you have anything right now? I want to ask a follow-up, just based on the defendant's argument at trial regarding the doctrine of necessaries, and give the doctrine of necessaries,
Yes, sir.
as he argues it there at trial, in terms of providing medical care and the cost of medical treatment, and the common law doctrine. Why wouldn't that common law doctrine be enough in this case to create that duty or bond between them to act as in Mason?
So is your question basically, are you asking whether the doctrine of necessaries should be extended to, why shouldn't the doctrine of necessaries be extended to this particular situation?
Correct. Or why wouldn't it apply at all? If you have a response to that, since it was argued by counsel below.
I would say that because there is no case law in point that creates any sort of a duty to rescue on this particular case, there is no doctrine of necessaries that wouldn't apply here. I believe that, I think you made, or maybe counsel made reference to, if there was a duty to rescue, then anybody at that hotel possibly could have been convicted of a crime. Because you saw that the defendant actually went upstairs to see, I think, 2 other rooms at the end of this vicious beating. And so at that point, it just becomes a question of how far does this doctrine of necessary stretch? If these other 2 people were aware of it, even though they had nothing to do with committing the crime, they know very little as to what's happened in that room. I think you just go down a dangerous path to applying the doctrine of necessaries to this particular set of facts.
The doctrine of necessaries is different than the duty to rescue. The doctrine of necessaries applies to an obligation of one spouse to pay for necessaries,
Yes, sir.
medical expenses and such of the other in the event that they are incurred. I think the purpose of Judge Murphy's question, and he'll correct me if I'm wrong, was to get your position in regards to whether the doctrine of necessaries established that necessary relationship that we talked about in the other cases.
Yes, sir.
I'm sorry for misapprehending your question, Judge Murphy, and thank you for that clarification, Judge Carpenter. I don't know that the doctrine of necessaries in this particular case would extend to this particular situation, because we still don't have any sort of law on point that kind of creates that kind of special duty. And even if the doctrine of necessaries does apply to this particular case, you still have the facts that still establish that this is second-degree murder, regardless. And I think Even if the doctrine of necessaries does apply, the malice is still there. You still have the elements of second-degree murder that have been satisfied. The crime has still been done, and I don't believe that the doctrine of necessaries or any sort of special relationship would drop this down to an involuntary manslaughter from a second-degree murder, given the facts that we have in front of us.
On that question from Judge Murphy, it brings up an interesting point, counsel, because the state is happy to use that special relationship as an aggravator. So is it not arguable that the defendant could argue that relationship and special bond in requesting this instruction based upon the state using it against them as an aggravator?
So in response to that, Your Honor, I would say that the aggravator comes with the sentencing part of it. And so we're not talking about the sentencing part of it. Right now, all we're talking about is what instruction should have been submitted to the jury. So therefore, I don't believe that that particular point would be brought to the jury at the point that a jury instruction would be issued to the jury.
We discussed the aggravator as it relates to the malice argument that you made earlier.
Yes, sir.
So we can't have it both ways. We can't say, well, Judge, you can consider the heinous act as an aggravator when it comes to establishing the facts of malice, but not when it comes, you can't consider the other aggravating factor in establishing the relationship. You got to pick.
Okay. So, Your Honor, what I will do is I will say, forget about what I said about the heinous nature and the jury finding that it was a particularly heinous crime. And you can see from the record, without any sort of jury finding or whatever, that this was a particularly heinous crime. Just looking at the evidence all by itself, without looking at any aggravating factors that the jury found, you see that she had a broken jaw, she had a broken nose, she had broken cheekbones. Basically, her face was moving as a result of the assault that the defendant committed against her with his fist, a deadly weapon. And so, therefore, I would say you have the intent, you have the homicide, because all of the medical experts have said that the assault was a proximate cause of her death. And therefore, I think that we are at second-degree murder. Regardless of any sort of special relationship or whatever, there was malice and there was intentional act that proximately led to Nadia's death.
Thank you.
Thank you.
Thank you.
Thanks, sir. Brownhouse? And I'm showing you at about just under 4 minutes.
May it please the court, I just have several points in rebuttal. The first is, the issue in this case is not sufficiency of the evidence. The issue is not whether there's sufficient evidence of malice. The issue is not whether there's sufficient evidence of causation. There is. Nobody's arguing the second-degree murder conviction is to be set aside. It's you're entitled to a lesser-included offense, even if there is evidence of malice. That's not conclusive. Second point is, I believe my colleague said that there was no intention to inflict serious bodily injury in the Debase case. I think that's a stretch. You take a bottle and you're beating somebody in the head with it until it breaks, and you continue to beat the person, and then you roll him into a fire. That seems to me some evidence of intent to inflict serious bodily injury. And he was convicted of second-degree murder, and this court didn't set it aside as being insufficient evidence. It simply said the defendant was entitled to instruction on the lesser-included offense. Third, I'm hesitant to wade into the sentencing issue questions, but certainly you can have a heinous, atrocious, and cruel involuntary manslaughter. That doesn't mean that there was compelling, uncontroverted evidence of malice. So that's, again, sort of goes with the sufficiency issue, my comment about sufficiency. And lastly, and I am really hesitant to wade into the issue of presumptions, because I think we learned those in law school, and then it was so ethereal, maybe we don't remember exactly what it is. But the Bush case was set aside in federal habeas because it was contrary to Sandstrom v. Montana, where the U.S. Supreme Court said you cannot have a presumption on an element in a criminal case. So there isn't any presumption lurking around here. And there's certainly a permissible inference.
It's mandatory presumption.
Mandatory presumption,
Unconstitutional.
correct. And so we have to be careful about using the word presumption without a qualifier. And I think that, in addition to the problematic nature of looking at the Bush case, is the state's reliance on Smith shouldn't compel this court at all. Smith was a murder by poison. And under the law in North Carolina, a murder by poison is first-degree murder and nothing else. You don't even get an instruction on second-degree murder if the murder is by poison because of the way our statute's written. I don't happen to like that interpretation as a defense lawyer, but that's what our state Supreme Court has said. So Smith being a poison case is a critical distinction that shouldn't cause this court to come to the conclusion that Smith says in this case there's not sufficient evidence to have an instruction on involuntary manslaughter. For those reasons, we ask the court to reverse.
Mr. Whitehouse, let me ask a kind of procedural question. If we agree with you on your argument, which starts at 21, I call the B1 argument, that culpably negligent in regards to the assault, if we were to agree with you there, do we need to reach your B2 argument of the assault plus the omission?
No.
Or it becomes moot?
No.
Be your position? Judge
Thank you.
Carpenter, anything else?
There was something else, I just can't remember what it was. So I'm going to let you off the hook, Mr. Whitehouse.
So I should run quickly.
That was always my theory when I was practicing.
Thank you, Your Honor.
Get out before the outcome changes.
Thank you all very much for your arguments and your skill this morning. We will take 20-660 as submitted, and thank you, everyone. Have a great day.
All rise.